Swayam Prabha. Digital India. Educated India.
Dear students, welcome to the fourth lecture of Transfer of Property Act. This lecture is about the transfer to unborn person. So, in last lecture, that is in lecture 3, I have discussed about the non-transferable things or right, that is mainly the section 6. So, in this case, that is in lecture 4, it is a very specific section 13 and 14, which talks about the transfer to unborn person. Okay. And I am going to discuss in detail about it, that what are the rights, how it is transferred, what are the main consideration at the time of transfer to unborn person. All these things we will see under section 13 in detail. So, now I am going to start this. So, what will be the major area which will be covered under this article or section is that transfer to unborn person, section 13 itself. Within that, we will discuss about the prior interest, absolute interest, perpetuity, rules against perpetuity, section 14, maximum remoteness of vesting and contingent interest. So, these are the focus area around which this lecture will go on. So, first is about the transfer to unborn person. Transfer to unborn person is discussed under section 13. As we know that in case of transfer of property, this transfer of property has been said that it must used to happen between living person. So, living person, whether this unborn person is living person, and when any unborn child will be called as a living person for the purpose of transfer of property act. So, an unborn person means a person not in existence even in the mother's womb. That means their existence, his existence is not at all on this earth. That means whether it is within the mother womb or outside the mother womb in this earth. So, that person is called as unborn. That means there is no news about that person that he is in existence. So, that person is called as unborn person under this act. A child in mother womb is considered to be a competent transfer. A child in mother womb even of 2 months, 3 months child is a competent transferee, and he will be treated as living person. That means, as living person, property is transferred to living person, in same way property will be transferred to the unborn child, okay, but it will vest only after the taking majority. So, in that way property can be transferred, but the right will vest only after taking majority. So, but in case of unborn person, rule is completely different. So, therefore, the property can be transferred to a child in the mother's wombs, because the child exists at that time, but not to an unborn person who does not even exist in the mother womb. So, transfer of property may happen to unborn child. If the child is born, there is no problem at all. If child is not born, it is unborn child in mother womb, even there is no problem. Only thing is that vesting of rights will accrue after the majority. But if the child is not in existence at all, then it will fall under the category of unborn person, and section 13 is for that only, that once any person, living person, want to transfer the property for his or her future generation after 2-3 grandson or son in future, or grandson, grandson, then what will be the law for that? So, this law, that is transfer to unborn person, is for that reason only. Now, transfer to unborn person. Every transfer of property involved with transfer of interest. So, as soon as there will be transfer of interest, the transferor is divested from that interest, and that will go, or it will be vested into the hand of transferee. So, for the vesting of interest, it is necessary that transferee must be in existence. If transferee is not in existence, then it will not vest. Vesting of the right will happen only if he is in existence. Okay. So, vesting is not possible without existence. So, interest will remain in abeyance till the transferee comes into existence, and this is against the concept of an interest. That means, if transfer is going to be made for a person who is unborn, just like suppose someone is going to make a will, that I am going to give this whole property to my grandson directly, and in between this transfer is not going to in the hand of anyone. So, the death of that person, if the Mr. A did like this, and his grandson is B, his grandson is C, and grandson is D. So, if A is making a will that it is going to be transferred to his grandson, and in between there is no vesting of interest, then whether this kind of transfer will survive in law or not. Okay. So, illustration has been mentioned under the section 13 itself, which says that A transfer property of which he is the owner to B in the trust for A and his intended wife successively for their lives. That means, A is transferring the property to B in trust, it is important, in trust for A, that and his intended wife successively for their life, that wife is going to continue for life after the death of survivor for the eldest son of the intended marriage of life, and after his death age second son. The interest so created for the benefit of the eldest son does not take effect, because it does not extend the whole of the age remaining interest in property. What it want to say this illustration? A has transferred to B, B is going to survive, and if going to survive, then in that case surviving wife will have children. So, he want to transfer to the eldest son, but this will come at the end to the eldest son. Before that, he is transferring, not transferring, that he is saying that this property will remain in the hand of younger son, okay. Then to the eldest, and this property is in trust, that is the problem. So, this property which is in the trust, and this is going to be held for whole life by wife, by his younger son, and ultimately it will go to the eldest son in trust. So, the whole rights relating to that property is not going to the eldest son. So, it has been said that this age remaining in this, because it is does not extend to the whole of age remaining interest in the property, then it is not a proper transfer. So, this will be not a valid transfer. So, whenever anyone is going to make transferred for unborn, then in that case it has been said that the all rights related to property should go when it is going to be divested to that unborn person. Okay. So, in that way it works. Then essential to invoke section 13. What are the essential? It says that this section 13 provides that the property cannot be transferred directly to an unborn person, just like I gave the example earlier, but it can be transferred for the benefit of an unborn person. For transfer of property for the benefit of unborn person, two conditions are required to be fulfilled. Okay. What are those conditions? The first condition is prior life interest must be created in favor of a person in existence at the date of transfer. First condition is prior life interest, just I will explain it. And absolute interest must be transferred in favor of unborn person. That means, if any person want to transfer, his property to unborn person, so first of all he will create the prior life interest. First thing, what is prior life interest? Prior life interest is a kind of limited interest. That means, just he is the carrier of the property, because ultimately absolute right is going to be vested into unborn child. So, unborn child is going to get, or say this unborn person is going to get the whole right related to that property. So, the person in between, that means the person who is the executor and the person that is unborn person, in between there may be number of prior life interest person. Okay. And this prior life interest person will carry that property one by one if there is more than one. So, first it will go to Mr. If it is going from A to B, then B will be the prior interest, B to C, that C will be the prior life interest holder, C to D prior life interest holder, and ultimately it will go to the E, who is unborn person, and A has assigned all rights related to property to E. So, this B, C, D will be called as this prior life interest person. Their interest is only to carry that property, that it should reach up to the unborn person. Okay. So, these two conditions are must. So, the first is must be created in favor of person in existence. That means, every person who is in between unborn person and the this creator, in between the person, that property must go through living person. If there is a break at any stage of the living person, that means to whom it was about to go, that person died and chain has already broken. So, in that case property will return back to the first one who has given to the unborn person. So, chain should not break and it should reach up to the unborn person first, and once it will reach to the unborn person, then what will happen? It will go with absolute condition, absolute right. That means, all rights related to that property will go to unborn person. So, what is this prior interest? It has been explained. It is necessary for a valid transfer of property to an unborn person, that before the transfer actually take place, prior interest must be created in favor of living person on the date of transfer. Yet it may be one prior interest living person, there may be more than one prior interest living person. Unborn person must be in existence when the prior interest come to end. This is a very, very important point. What I told you, that unborn person must be in existence when the prior interest comes to end. When the prior interest comes to end, in that way, before that this unborn person must be in existence. At least that unborn person should be in womb. If it is not the in existence on earth, but at least it should be in womb. If it is not in womb and the prior interest person died, that means there is a break of chain, and if that is there is a break of chain, then the whole property will go to the first person who has given to the unborn person, and then because he is not alive today, so their heir will be, his heir will be claiming all the shares which was going to the unborn person. So, in that way it is happened. So, after the death of the person who had a life interest, the property would ultimately pass to the unborn person who would by that time have come into existence. So, example has been given, a transfer his property to X for life, then Y for life, then Z for life. Okay, that means all will X for life, Y for life and Z for life, they are with the prior interest. Okay. And then after to unborn child Z, then after this unborn child Z. Okay. So, here X, Y, Z are living person, X, Y, Z are living person. The property may be given to more than one living person successively for life before it vests to an unborn child ultimately. So, in that way it goes. So, these are the prior interest portion. A property was transferred by way of gift deed in favor of donor's grandson. Donor's grandson, the donor has transferred the property to unborn person, that is grandson. Thereafter, the property was to be vested in the male children of the grandson. The court said that the gift deed created interest in favor of grandson and absolute right in favor of unborn son. The condition in the gift restraining alienation was held not void. Okay. That condition in gift restraining alienation was held to be not void. Alienation of the property by donee after the birth of his son was improper. Alienation of the property by the donee after birth of his son, because his son was what was the interest? Prior interest. Okay. Was improper. The son were held entitled to the sale consideration received by their father from purchaser. That means, if there was any agreement which has been not agreement, that is any this will type things have been made, that it will go to the grandson, and before that he has already transferred the property. So, this transfer of property has been done by whom? By the donor himself. So, in that case this unborn person rule will not apply, and whatever the consideration will come by the alienation or transfer of the property to the person, their son will claim portion of their own from that property. So, this is important because it has been done during the life prior interest itself, and the donor himself done this, because this cannot be done by anyone except the donor. The donor wanted to give to the grandson, before that he has already alienated the property. But if it would have been transferred after the death of the donor, then subsequent prior interest person would have not that kind of right to alienate it and deposit all the sum to the on the name of that person, unborn person. This is not possible. Then absolute interest. Okay. It is further necessary that the whole of the remaining interest of the transferor in the property must be given to unborn person. What is remaining interest of the transferor? Remaining interest of the transferor, that means whatever the title was with the donor, the whole title will go to the unborn person. So, unborn person is entitled to take all the rights which was vested with the donor. Only absolute interest may be transferred in favor of unborn person, not limited or life interest. This is also important part. That means, with condition property will not go to unborn person. With condition it may go to the living person, but it cannot go to the unborn person, or with limited interest it cannot go to the unborn person. With life interest it cannot be go to the unborn person. So, the whole of the remaining interest in the entire interest of the transferor less the prior life interest carved out of the ownership. In the illustration of this section which I have discussed in the last slide, the transfer to unborn person, eldest son, become void. Why it has become void? because the whole property was in the form of trust, and in the even the life interest was in continuation in the form of trust. So, when it went to the younger son, that was also in the form of trust. So, when it went to the younger son in the form of trust, and then it was going to be divested to the unborn person, and that was in the trust form. So, in the trust form it will not divest to unborn person, and in that way it was completely void. So, the given illustration of section 13 itself is a kind of void transfer, which is not permissible for the transfer of unborn person. Okay. So, in that way it has been given into this. Next important point is rules against perpetuity. It is also related to unborn person. Rules against perpetuity. Perpetuity means what? It is about the continuity. So, when we talk about the perpetuity, this perpetuity is related to interest in property itself, okay. And rules against perpetuity. Rule is that any property should not be ownerless. Any property should not be ownerless. So, any condition should not be made which will create a kind of things that it will be not transferable in perpetuity. Okay. So, it is always in the interest, I told you earlier also that it is always in the interest of property as well as of the society that property should always be in the form of transferable form, not I will say movable. It is not about the immovable property should be transferred continuously, that means one generation to other to another generation, like that. So, the perpetuity means continuous or unending transaction. In that way, unending transaction, it is tying up properly for an indefinite period. It is tying up property for an indefinite period. Transfer involving generation after generation, peedhi dar peedhi are known as creating perpetuity. That means, a property is going to be transferred from one person to another to the third person, generation to generation. This is the modern law of perpetuity. Old law of perpetuity was that what has been said by the German, the perpetuity in the primary sense of the word is a deposition which makes property inalienable for an indefinite period. So, this is a kind of old concept, that the perpetuity in primary sense of the word is a disposition which makes property inalienable for indefinite period. So, here we are not talking about the making property inalienable, that means which cannot be transferred for unlimited period. That means, in perpetuity it will be always non transferable, that is not the case. Now, the meaning has been just opposite to it, that means it is transferable in unlimited period. That means, property should be always transferable up to unlimited period of time. The old concept was that a property should not be restricted in a way that it should not be transferable, non transferable for long time. So, it is concerned with certain interest created in presenti means the present person, which are sought to be made inalienable for an indefinite period. This section is known as modern rules against perpetuity. Modern rules against perpetuity, that means rules has been made that there should not be any kind of restriction which will result into non transferability in perpetuity. So, there should always be transfer. So, here it has been said that even in the case of unborn person, you are going to transfer to the unborn person through the life interest. Okay. So, it will continue. The person will have limited interest in between, but later on with absolute right it will result to the it will go to the unborn person. So, rules of against the perpetuity is a modern rule. Object of rules against perpetuity. What are the objects of this rule? The first object is that to ensure free and active circulation of property, both for purposes of trade and commerce as well as for betterment of property itself. I have already told you. The frequent deposition of property is in the interest of society. Disposition of property is in the interest of society and also necessary for its more beneficial enjoyment. That means, property rights should not be in a single hand. There should not be accumulation of wealth in a single hand or to the group of people. Wealth or any kind of right always should be movable. That means, one person to another, another person to other, and in that way wealth flow in the society. So, this property law, that means a person have a property right, should always go from one person to other person to another. That in that way actually it will serve the purpose. The property itself, it will serve the purpose. That means, maximum utility of property will happen. Otherwise, what will happen? If the property will be in the hand of few, then only the few will enjoy the property, rest will not enjoy, and even the few will enjoy, they will not enjoy up to the fullest extent. So, there will be maximum utilization of property is possible only through the maximum number of disposition of the property. So, for that purpose it has been said that there should not be any kind of restriction which will restrict the alienation or transfer of the perpetuity or perpetuity in long term. So, essential element of rules against perpetuity. So, first is that there must be a transfer of property. Second is transfer is for the ultimate benefit of an unborn person who is given absolute interest, and the vesting of interest in favor of animate beneficiary is preceded by life or limited interest of living person. So, rules against perpetuity requires three things. First is the transfer of property, then its transfer must be for the ultimate benefit must go to the unborn person, and the vesting interest in favor of the ultimate and animate beneficiary. Okay. So, this then ultimate beneficiary must come into existence before the death of the last preceding living person, and vesting of interest in favor of ultimate beneficiary may be postponed only up to the life or lives of living person plus minority of the ultimate beneficiary, but not beyond that. So, this rules against perpetuity, what it says, that up to what extent maximum transfer, that means time can be taken for the grant of the rights or transfer of the right to the unborn person. So, this is the rules against perpetuity. Why it has been said? That means, once the property is going from the donor or transferred to the transferee, then it should not for the perpetuity. It is for, that means, it must go to the someone to whom it has been going to be given. So, it is against the perpetuity. Against the perpetuity means what? That now this there will be transfer of the property, and there will be no stuck or there is no stop of the circulation of the property or rights of the property at some stage, which will hamper the interest of property and society at all. So, in that way it is rules against property. So, one by one all these 5 things I am going to discuss in detail. So, this rules against perpetuity says that where the property is made to vest within the limit prescribed in this section, the transfer is valid. Any delay beyond the period would make the transfer void, and accordingly where a property is transferred to A for life and then to unborn child or unborn person when he attains the age of 19 years, the transfer to unborn is also void under section 14. What it want to say? It want to say that whenever there will be transfer of any property, then what will the maximum time to reach to the intended transferee, that has been given. So, it has been said that up to the property must reach up to the intended transferee within the stipulated time what has been given in that deed. That if this life interest person are 3 or 4 and the 5th one is the unborn person, so during the life of the life interest person it must reach to the unborn person. Okay. Otherwise, what will happen, that I told you that there will be a break and ultimate break of chain and ultimately to return back to the original one. So, here it says that where the property is transferred to A for life, for A for life it has been transferred, and then up to the unborn child up to the 19 year. So, 19 year not the rule. Rule is that the property will be divested to the unborn persons once he will or she will get the age of majority. Okay. So, after 18 years, or if the court has appointed a guardian, in that case 21 year, in these cases property must reach to unborn person. That means, life of the life interest person life plus the age of majority. Okay. So, maximum it may go up to that time, not beyond that. So, the main formula for calculating is this. We will discuss in detail in the coming slides, that how you can determine or how you can go through the maximum remoteness of vesting. This is a very important and very important concept under the Transfer of Property Act, and generally practical problem is being asked in the various examinations. So, this concept is very important for the all purpose, that what will be the maximum remoteness of vesting. So, first of all, try to understand what is the remoteness of vesting. Vesting means that now rights is going to the unborn person. Okay. That whole right is going to be, not only right, maybe the right has been created by the donor with the life interest person. Okay. But life interest person has a limited right. So, once the full rights related to the property is going to be vested to the unborn person, that is called vesting of rights. What is the remoteness of vesting? Remoteness of vesting means what will be the maximum period within that right must be vested, that is. Okay. So, maximum remoteness period what can be? So, first of all, there cannot be a single maximum remoteness period for any vesting to unborn person. Completely it will be dependent on the instrument that the donor has assigned how many life interest person. First of all, first criteria is that if the number of life person is more, in what which subsequent generation unborn person is coming, accordingly the remoteness will be determined. Okay. So, it will vary according to the problem. So, here it has been said that according to the section 14, the maximum permissible remoteness of vesting is the life of the last preceding interest plus the minority of ultimate beneficiary. What is the meaning of this? That the last preceding interest plus minority of the ultimate beneficiary. Accordingly, now this example is given, that property may be transferred to A for life, then B for life, and then to the unborn person when he attains the age of majority. So, A and B hold the property successively for their lives. Therefore, property is tie up for their lives once after the other. After the death of B, the last preceding interest, although it should vest in the ultimate beneficiary unborn child immediately, but under this section the property may be allowed to vest in the unborn when he attains the age of minority. Okay. And minority in India terminates at the age of 18 years and or when the minors is under supervision of the court at the age of 21 years. So, take the example of this, that if person A has transferred the property to unborn person through life interest person Mr. Mr. B. Okay. So, Mr. A for life and Mr. B for life. So, life, suppose B is the survivor of A, that means A died first and B died later on, but B died later on means before the death of B, this unborn person must come in the womb of his or her mother. Okay. Then only this all instrument will survive, otherwise not. So, here it has been said that at death of B, although it should vest in the ultimate beneficiary B ultimately, but under this section property we will allow vest in unborn when he attained the majority. Majority means, that means after 18 years, if court has not appointed the guardian. So, in that case what will happen, that suppose person A has transferred for D, and B and C is have a life interest. So, A died in 2015 and B died in 2022 January. So, before dying of the B, that is 2022 January, unborn person was in this on this earth. That means, he might have taken the birth in 2019, 2016, 15, whatever it may be. Okay. But in January 2022, if he has not taken birth, then he must be, or she must be within the womb of his mother. Then only property is going to be divested after 18 years from the date of birth. So, suppose the person took the birth, death of B was in January 2022 and person took the birth in June 2022. So, June 2022 and he will attain the majority in 2040. So, in that case all the rights related to property will be vested into the unborn person in 2040. Okay. So, in that way it works. Ultimate beneficiary in the mother's womb. This is the criteria under this section 14. What it says, that where the ultimate beneficiary is in the mother womb, that is, it is the child in ventre sa mere. The latest period up to which vesting may be postponed after the preceding interest is the minority plus period during which the child remain in mother's womb. That minority is counted from the date of worldly birth, whereas for the purpose of being transferee, a child in mother's womb is competent person. Okay. So, where the ultimate beneficiary is in the mother's womb, when the last person dies, the property vests immediately within him while he is still in the mother womb. Okay. So, what it happens, that when the property is going to be vested. So, this is the remoteness of this beneficiary, that this when it is actually going to be vested. So, it has been said that if the person is in the mother womb, okay, the latest period up to which the vesting may be postponed is the minority plus period during which the child remain in mother womb. So, generally it is asked that if the last survivor, that means life, that is last life interest person had died, life interest person died in 2022 January, then up to that time he was or she was in mother womb. Okay. It may be 2 months, 3 months, 8 months. So, actual delivery date, actual date of birth plus what was the time of the person which was in the womb after the death of the last person in interest. Okay. That will be the maximum period. In that way, take the example here, the formula is already given here in section 14, ultimate beneficiary in the mother's womb. The maximum permissible remoteness of vesting is life of preceding interest. Life of preceding interest, it may be Mr. A, B plus C plus D, it may be like this. So, it and it was done, this agreement was this actually it was done in 1985 by a person, that it will go to the grandson interest. So, what will happen, that A, B, C A and B were the wife, spouse A and B, whoever is and C was their child, D was C child, and ultimately property was going to be divested into E. E was the unborn person. So, what will happen in this case, that if A dies first before the B, okay, A dies in 1990, then B dies in 1998, then C was a son who died in 2012, and D died in road accident in January 2020. Okay, 31st January 2020. So, what will happen in this case, that is property is going to come to E, then E must be in his or her mother womb prior to 31st January 2020. Okay, prior to 31st January 2020. Then what will happen, that how you will calculate this remoteness? So, remoteness you will calculate that from the first date itself 1985. So, if on this date there are two possibilities that E was in existence, that means E was of 3 years on 31st January, okay, and E took the birth on 31st January 2022. So, 1st June 2020. Okay. This is the case. This first case is that he was already in existence on 31st January 2020. Okay. Okay. So, what will happen? Now, what will be the max in first case, when E was in existence? Now, take the total time period 1985 till this on 31st January he was in January 31st he was 3 years. So, after 15 years he will take majority. So, after 15 years means now we will add 15 years in. So, suppose in January 2020 35 he will take majority. So, all property in first condition will divest on January 30, 2035, if his date of birth is 1st January in this case. In second case, if he took the birth because he was in womb, so he took the birth on 1st June. So, he was that means at the time of the death of Mr. D, he was in womb of 3 months, okay, 3 months. So, after 6 months completing 9 months, there was a birth of this child, and then from this it will be counted again 18 years, 1st June. So, all the property is going to be vested on 1st June 2038. 38, that is period of gestation of ultimate beneficiary. So, period of gestation is what? Period of gestation is here 6 months, death is into January 2020, period of gestation is 6 months, that is from January to 1st June. So, this 6 months plus 18. So, 18 years plus 6 months it will be gestation period plus minority of the ultimate beneficiary 18 years. Okay. If he was already born, then whatever the years left in the majority, that will be counted. So, in the first case that the property will vest in 2035, in second case it will vest on 1st June 2038. So, in that way we calculate the maximum permissible remoteness of vesting. Okay. And this is always keep in mind that this period of gestation is important. Why? Because before birth the last person that last person in interest has already died. Third probability will be what will be that the person dies in on 31st January 2022, Mr. D, but he took birth on to the 1st January 2021, that means after 1 year. So, after 12 months, meaning thereby at the time of death he was not in womb. So, when he was not in womb at the time of death, then what will happen? Then there will be no such kind of calculation at all. There will be no requirement of such kind of calculation. Simply property will go to the Mr. A, and because A is already died, so the heir of A will take these property. Okay. Heir of A will take these property, and in this way it will work. So, I think ultimate beneficiary rule for counting this maximum permissible remoteness of vesting should be clear with this example. Next is the same. I have explained you this all these things here, that it transfer certain properties to X for life and then to Y for life. So, this is a kind of revision, or you can say you can go through it and set your own, because this things has been specifically mentioned that on the basis of this formula you can do the practice also, that you can create your own situation in which you can calculate the total term of this remoteness of vesting, and accordingly you can work over it. So, in this I have said that A transfers certain properties to X for life, then to Y for life, then to unborn when he attains the age of majority. X and Y are persons living at the date of transfer, and unborn is the ultimate beneficiary not in existence even in the mother womb. Here the last preceding life interest is with Y. Y dies, the unborn must be already in existence either in the mother womb as a child of say 6 months, or a born child of say 6 years. Okay. So, I have given you example of both. This when he was in the mother womb, that means took the birth on 1st June 2020. In this case, I have given that he was already born in 2017. He was of the 3 years at the time of the death of the last beneficiary, and in that way we have calculated. So, maximum term of this remoteness will be life of Y plus 6 month plus 18 year. Okay, because here this life for life of Y and this under this condition, then life of Y plus 18 years, because it is the last term. Okay. Generally, if you will count from the first date, then you will have to take the life of all the life interest, then the whole remoteness will be counted. Otherwise, remoteness means with the life interest, that the person, the last person which had a life interest, and then the age of majority, or if there was the person was in the womb, then the period of gestation at what stage, what was the stage in the womb at the time of the death of last beneficiary, sorry, last this life interest person. Okay. So, in that way you used to calculate. The next point is this Shunda Rajanam versus Natarajan. Shundra Rajan versus Natarajan, the Privy Council held in this case, since at the date of the transfer it is not known whether or not a guardian would be appointed by the court for the minor in future. In such a case, for the purpose of section 14, the normal period will be the minority would be 18 years. Therefore, vesting may be postponed up to the life of the last person holding property for his life and the minority of 18 years of the ultimate beneficiary. That means, meaning thereby, if the person, that is, if there is a confusion that who has allotted, who has going to be given this ultimate, who is will the ultimate beneficiary and what will the last this remoteness, then in that case what has been said, that if the court has not appointed or there is a confusion that whether it is 18 years or 21 years, court says that take 18 years, which is a general rule. If it will be appointed prior to the 18 years and the guardian is going to be appointed by the court, then certainly it will be converted into 21 year, otherwise 18 year will be a general rule in that case. Okay. Next point is about Ram Nawaz versus Nandu. Ram Nawaz versus Nandu. This is the 1926 case. It is a very old case. In this case, what was happened, that it has been said that even if at the time of transfer of property, there is a slightest possibility that in the future it will be a transfer in perpetuity, the disposition will be void. Disposition will be void. That is, if there is suspicion about perpetuity, because we are discussing about the rules against perpetuity. The something is going into perpetuity, that means this is going to be used for a long time and there will be no transfer in it, no transfer of the property in long term, that is going to stuck at certain stage, and if there is possibility, then that transfer will be void. Okay. What was happened in this case? This is a very interesting case, and you should understand that some portion was dealt with some type of different type of transfer, and some portion of the property was dealt with a different kind of transfer. Okay. Then what was happened here, it has been said the term of the sale included a condition of 2 bighas of land would remain in X possession for life, and after his death the possession of X lineal descendant. Okay. So, and rest of the property was sold except 2 bighas. The rest of the property was sold except 2 bighas. Then the condition further added that X or X lineal descendant had no right to transfer the land, and if none of the X lineal descendant is alive, then the property shall be the own property of Y, who is the purchaser. X had only one son who was alive on the date of transfer, but he died childless. Okay. Then what happened? The transfer of this land of Y was held valid, except the transfer of 2 bigha was held to be void. Why it has been said? Because the all the for X has sold his entire property except those 2 bighas. Okay. And X was sold this was in possession for that 2 bigha was in X possession for life, and then after their lineal descendants. So, and rights has been said that no one can sell it. So, when no one can sell it and it will be only to the descendant, and ultimately there was no child of the descendant, then what will be the fate of it? So, it has been said by the court in this case that all the transfer, all the sale was valid one, but except these 2 bighas which was kept for own purpose, and ultimately it was not resulted or it was not going to any lineal descendant. So, suppose there was a 50 bighas of, and out of 48 it has been already sold, only 2 has been kept, and in that way there was no such kind of there was no such kind of transfer ultimately happened, and it remained in the hand, it has no use in future. So, court said that for 2 bighas it will be void. Okay. The court has given direction in that way. Next is contingent interest. Contingent interest is also within this rules against perpetuity. The vesting of interest in favor of the ultimate beneficiary may be postponed till his minority. That means, once he will become the major, then he will have all right in that. So, up to the becoming major, okay, this is a contingent one. That means, all rights is going to be vested after 18 years after taking the majority. So, between the period of the last person having prior life interest dies and the unborn person who is ultimate beneficiary attained the age of majority, the ultimate beneficiary has only a contingent interest which becomes invested in him when he attains the majority. So, where the ultimate beneficiary is already born at the death of the last person, but does not survive to attain majority, the interest does not vest in him, but revert back to the transferor or his legal heir if he is dead at that time. So, it is very rule of perpetuity is very clear. It says that the unborn child if came into existence, then after 18 years it is going to be vested to the after 18 years it will be vested to the unborn person, that means who has already attained the majority to whom it has been transferred. But if prior to that if something is happening, okay, and there is a death of that person against whom that transfer has been done, then again also because it was not vested, person was already in existence, there was this right was contingent right, contingent, that means after majority he will gain all those rights. So, again it will be vested to the original creator, original transferor, okay, and their legal heir will claim rights over that. That means, if the unborn person has not attained the majority, till then right has not been transferred. Okay. So, this contingent right is related to unborn, because unless and until the maturity will not be gained, majority age will not achieved, it will remain as only vested right. It is not going to be a vested one. Okay. It become invested him only after the age of majority. So, in that way it is all about the transfer to unborn person, and I have finished the lecture number 4, and it in detail I have discussed all these things, specifically the remoteness of calculation of this period is very important, which must be exercised properly. So, it is all about transfer to unborn person. Thank you.